Okay, awesome.
Cool.
So I am going to monitor for anyone who starts. We'll wait just a minute and see if anyone joins in. And we are recording. Okay, welcome everyone as you're coming in. We will get started in just a moment. Nice to see everyone here. Hope everyone's having a good Friday so far. It is blazing hot here in Buffalo and we don't really like AC, so I'll try not to pass out. How's the weather in Colorado, Justie?
It's actually rainy yesterday, so it's about 60 degrees right now, maybe a little bit warmer, 62. So my dogs are inside instead of outside in the rain because they're, you know, pampered. And this one is like, I must appear on camera at all times. So he's right here.
Oh, nice. He's just there keeping you company. Does he cue your notes up for you?
Yeah. He likes to make appearances in our morning team meetings too. It's way better. It's either that or the horse. I mean, you know me. I'll put the horse on camera too.
Maybe you'll do a Zoom from horseback one time.
I haven't taught one yet. I have done plenty of Zoom conferences from horseback.
Right, exactly. You can have maybe your GoPro or something.
There you go.
You know, one of those like selfie sticks, right? Okay, so we will get started. Awesome. So everyone, thank you for being here. We are so happy to invite you to join us today for a discussion on protester rights, First Amendment rights, and how that's currently playing out today and with a historical perspective. So we've got Valerie McConnell here from Casetext, which is legal research software powered by AI, and Justie Nicol from Nicol Gersch Law in Colorado, criminal defense and animal rights attorney. Did I get that right, guys? Can you introduce yourselves, please?
Yeah, go for it, Valerie. I'll let you start.
Sure. So as Maddy said, my name's Valerie. I'm an attorney and the director of support at Casetext. We are an AI-based legal research platform, and I will be sharing a little bit today about cases that will hopefully provide a good jumping off point if you want to research these First Amendment issues further. But the real world perspective is going to come from Justie.
Yeah, so I'm Justie Nicol. I am a criminal defense attorney in Colorado, and we're about to launch into family law, which has nothing to do with protests, but I'm a managing partner and doing a lot of protest rights litigation right now. We actually have signed a couple of new cases, took a few pro bono cases because of the protests here as well. So this is my daily life at this point. We have a number of other cases, where police have operated questionably. And I think I just got my last one dismissed. I think I may have one more in Boulder that I'm still working to dismiss. But yeah, the real life stuff, I'm in the trenches every day.
Wonderful. Well, I will just, before we get started, introduce myself. And there will be, for anyone who is asking, a replay available. So we are recording this, but I'm Maddy Martin, the head of growth and education for Smith.ai. We are a virtual receptionist service for attorneys and many other professionals. Justie is included in our clients, and I'm happy to often co-present with her and join on educational seminars like this. So I'm very happy to have our friends here today, and Casetext is a partner of Smith.ai as well. If you do need help, know that we are not only available for 24/7 receptionist and chat services, but that we are also, as part of this greater initiative, supporting attorneys who are serving those needs of protesters, and we are offering free call answering and chat answering during this time. So I will post a link to the document with more information on that, and you can get in touch with us if we can be of service to you. So without further ado, Valerie, it would be wonderful if you could sort of set the stage here and share, what is, in common parlance, your First Amendment rights, and how does that relate to the discussion today around protester rights?
Sure, absolutely. So I'm going to share my screen now. Hopefully everyone can see this okay. So I'm going to discuss a few key cases that pertain to the right to protest under the First Amendment, discuss some cases that you can maybe use for further research, and I'm going to pause between each discussion of these cases to ask the real world perspective from Justie, since she's the one in the trenches and I'm just hiding here in legal research. So the first set of cases that I want to discuss, which I think actually are a bit interesting, but it concerns whether you need a permit for protesting. Now, interestingly, you know, I think when people want to protest, they're not usually thinking about getting a permit, right? You know, they're usually pretty caught in the moment. They want to go out there and make their voices heard. But a permit is sometimes required, as shown here on this slide. Whether you need a permit can really depend on where, when, and how you want to protest. Now, what the government cannot do is require a permit for protesting when the protest does not hinder traffic or create a risk to the public or compete with others' use of public property beyond the ordinary uses of the space. So if you're planning an event that will block vehicle or pedestrian traffic, it is advised to check your local ordinances to see if a permit is required. So the cases that kind of frame this discussion, I put a few of them up here. The first case on my list is a case from the U.S. Supreme Court, Forsyth County versus Nationalist Movement. In that case, the U.S. Supreme Court struck down an ordinance that required a permit and a fee for public speeches and assemblies. And this particular ordinance was problematic in that it required a lot of government oversight and discretion. So people had to get approval from the county and pay fees before protesting or assembling. And that amount of government involvement and discretion to say who could protest what was found to be an unconstitutional prior restraint on free speech. Another case that discusses the right to protests and permits in particular is the case of Santa Monica Food Not Bombs versus the city of Santa Monica. This is a Ninth Circuit case which invalidated a city ordinance that required any individual that was promoting an event to obtain a permit. And this was just a blanket rule. It applied regardless of the size of the event. You had to get a permit before organizing anything in public. Here, again, the problem was that the ordinance was not narrowly tailored. It was super broad. Now, in this case, the Ninth Circuit did recognize that a city could require advance notice and some coordination for really large events that would present traffic and other issues. But here, this ordinance just was too broad because it applied to literally any public gathering. And this proposition that the government cannot impose these broad permitting requirements on anyone who wants to have a public event was reiterated in the case of American Arab Anti-Discrimination Committee versus the city of Dearborn, a case from the Sixth Circuit. And I put up the pertinent quote here, where the Sixth Circuit said, permit schemes and advance notice requirements that potentially apply to small groups are nearly always overly broad and lack narrow tailoring. So the takeaway from these cases is that permitting requirements have to be narrowly tailored in order to be valid. There needs to be some legitimate government interest in public safety and the need for coordination to require a permit. A city can't just require a permit for any public gathering anywhere, regardless of the size. And a city can't impose a permitting system that requires a lot of government discretion, because then the government essentially gets to say who can protest what, which is unconstitutional. Okay, I want to pause now and talk to Justie, who's actually dealt with this. So one question I was thinking as I've been reading these cases is, let's say you are in a protest and the protest is not blocking traffic. An officer comes up to you and says, you need a permit to protest here. Any advice for what a person should do in a situation like that?
I think the first thing is determining where you're actually standing. So if you are standing in a place that blocks access to critical government buildings, even if it's a public forum, you might be asked to lawfully move. Other than that, you know, there's distinctions between protesting on a sidewalk, that's a public place, or protesting in the middle of the street. You know, we have some of these clips that are on Twitter and everything, where even here in Denver PD has literally ran over a protester and fired pepper spray and rubber bullets at protesters early on in the protest for being in the street. There's been no mention, from what I've seen, of a permit being required or requested, because most of the protests here in Denver, at least, and most that I've seen, you know, nationwide, are really happening in public spaces right now. Some of it, you know, is hard to control on a municipal level because there are wide open public spaces here. Universities and other places have designated free speech zones where permits for additional protests outside of those areas may be required. But really right now what we're seeing is less about you need a permit to be here and more you're blocking traffic, you're blocking access, this is out of control, and then curfew violations, which are completely separate. What we see a lot is, you know, in the middle of the day, the permit has been obtained for a march, which is on the streets. I know a number of organizers who have done that, including attorneys against police violence here in Colorado. They've actually pulled permits and shut down certain areas of traffic in order to safely march through the area. But what happens after that is they've reached their end zone, which is usually around the Capitol here in Denver, and then, or Civic Center Park, and then it just blows up from there. People don't disperse at the end of the event. More people are coming. It's growing in size, and then people are violating curfew, and that's after hours when we were seeing rioting and property destruction as well. So it's hard when you're the person or the group that is pulling a permit, and then you're done with your allotted time, but your attendees are kind of out of your control, right? Like if you're pulling a permit to block traffic, that's one thing. You've done everything you can lawfully to organize your right to protest. And when it morphs into something else is when you have to worry about additional liability too. So I've had other attorneys in other states, Minnesota included, reach out to me to also ask about sound amplification, because that's something that does require permits in a lot of places. So if you've got loudspeakers on your car in order to, you know, corral people or broadcast your message, usually that's fine, but that's something, because it can violate noise ordinances, that the city can crack down on as well. So sound amplification is something, you know, you might have to pull a permit in advance. I literally was like troubleshooting with a Minnesota attorney. She's like, what's the worst thing that can happen besides the sound amplification materials and equipment being destroyed? And I'm like, well, A, they should get new insurance or better insurance or up their insurance. B, you know, don't put who owns it on it, right? Like if you know, don't want to be burdened with it, don't put who owns it, just lend it to the group, that's fine. Make sure the group gets a permit or is aware of the permitting requirements before they broadcast and that sort of stuff. So some of it is like practical stuff. Some of it is permitting stuff. And COVID throws a wrench in everything. Because you're not even supposed to be outside.
A whole new world
Right.
of it, yeah, endangering, yeah, and your responsibility personally for taking care of your community and others who are in contact with you. And what role would that play, like, just to jump in here for a second, Justie, like there are some urban areas that have a lot of like residential space. So if someone has a private home and they're sort of near downtown or even apartment buildings and things like that, what role is there for like that private property to host these protests that sort of feels like it's in a public space but isn't actually? Is that sort of noise space, that community, considered affected?
So private property, just like the new slide here indicates, it's entirely up to the property owner what goes on their property, as long as they don't interfere with other properties. So I actually own a building in Fort Collins, which is right next to the Planned Parenthood. And we have had a number of protests for years and years at Planned Parenthood. And I should say we. The community has protested at Planned Parenthood in various forms. And as soon as it spills onto my property, they're very, very close to a driveway and a drive aisle. And we have had to forcefully remove protesters from our property because it's private property and you're blocking traffic. And if you get hit by a car in my parking lot, even though you're protesting at my neighbors,
right,
you know, like I'm somehow still liable for the property damage, like a slip and fall, anything like that, if you fall on my property or injured on my property. And if you're not lawfully present there, I can kick you off. So I restricted private property protests in that instance, but on the other end of things, I could also allow it. It's entirely up to me as long as my neighbors are not detrimentally affected, like in that case with car and pedestrian traffic. Signage, you can put whatever signs what you want up on your own property. You pretty much set the rules for your own property.
Okay, and but it's mostly with respect to the physical presence directly on the property and not like the noise generated around the property.
You still have noise ordinance complaints that are possible, just like you would with house parties when you're an undergrad, right? Like the cops get called because there's 50 kids that are tailgating before a football game. So you've got to be concerned about that. But if you're being respectful, you're not using profane speech or sound amplification to broadcast unnecessarily, you should be fine. Best tip I have is just talk to your neighbors. Talk to your neighbors in advance.
Be proactive. You mean in advance?
Yep. Yep. Let them know you're hosting something. And some of it is, you know, large commercial property owners could have a stake in this as well. Where our properties are in Fort Collins, we're right across the street from CSU. So we have a large student contingency. We could open up our parking lots to protesters just about any time we would like to, as long as we don't infringe on our neighboring businesses.
Got it. Valerie, sorry, back to you.
No, not at all. This is the purpose here is to, you know, have the discussion around the slides. I want to drag people through some old Supreme Court cases. And the reference to COVID made me realize that, you know, these cases, though useful, don't capture all the things that are going on right now. We probably have some very interesting cases dealing with COVID, protesting, and all that entails from a liability perspective.
Yeah,
but
I saw something on Facebook the other day, which was like, they've canceled our 4th of July parade, but they're allowing the protests to go on. And I'm like, wait a minute. This isn't different from historical case perspective. There's a government actor involved in one of these things, and then there's the constitutional right to protest and the freedom of assembly in the other. So the government doesn't have to host a parade for you on the 4th of July during COVID. Like that's just not going to happen. But they also, you know, aren't really enforcing stay-at-home orders nationwide anymore. I think most places are starting to lift those. So the biggest concern you have with the protests and violating your First Amendment rights are whether your First Amendment rights trump a curfew order and trump a stay-at-home order. So that's going to be some interesting case law that I think we'll see come out of this too, is somebody who's, you know, been charged with violating stay-at-home orders or violating administrative orders for the protection of the public during COVID versus their First Amendment rights. And I'm pretty certain your First Amendment rights are going to trump an administrative order to stay home during COVID. But we'll see what the Supreme Court says in probably like 3 to 5 years.
Right. Although actually, Justie, you raised an interesting point, which is not on these slides because the old cases don't deal with the situation. You mentioned curfew orders. How does violating a curfew order, how does that impact a person's right to protest? Or how do curfew orders impact the right to protest? Because actually that's something that I haven't seen much in the case law, which as you point out is going to be a big issue now.
Yeah, I haven't seen a whole lot of really authoritative cases on it. The problem is most curfews are set at the municipal level. And so the violation for a curfew is usually just a muni fine here in Denver anyway. it may or may not go on your background check. It's not necessarily like an arrest. I mean, it's probably an arrest, but it's not necessarily booked and reported to the national databases for purposes of a background check if it's only going to be a muni. But the problem that you have is you're seeing mass numbers of people arrested for curfew violations, really not booked everywhere, and released the next morning, if not sooner. And I think, gosh, LA or one of the major metro areas, their district attorney actually said, and I think it might have been Denver too, they said, we're not prosecuting curfew violations. So they just dismissed, I think, 320 cases or something ridiculous like that here, where it was like, what? But these people had to spend a night in jail anyway, right? Like, you choose not to prosecute that, that's great, but there's a disconnect between your DA and your law enforcement officers who are using this as a method to clear the streets. Curfews are a little bit hard, right? Like, there's not Supreme Court case directly on point that I know of. Maybe there is in Casetext.
I didn't find one either.
But there are some things in general that the police have to do if there's a clear and present danger of a riot or interference with traffic or other immediate threat to public safety. They can issue a dispersal order, which is maybe a little bit different than a broad curfew. But they have to give people a reasonable opportunity to comply. They have to give clear and detailed notice of the dispersal order, and they have to provide a clear exit route to follow. So what I'm seeing on like a national level is that those things really aren't being done. And I don't know what the liability to the police force is for that. But in terms of your rights to assembly, they only go to the clear and present danger to public safety line. Once that line just crossed, kind of all bets are off a little bit. But yeah, like the notice of the dispersal order, the opportunity to comply in an exit route, there's not like a map out there that they're giving to everybody. I mean, maybe they should push through an Amber Alert to everyone's Apple Watches and say, hey, exit route is here. But they're not taking advantage of technology or doing that sort of stuff. It's just a easy way to arrest a lot of people at this point.
One question as we sort of talk through, the rights of different individuals, one thing that comes to mind is minors and the role of maybe employers in permitting, and some of these conversations probably happening in the workplace. So maybe the first one we can tackle is parents who bring their children to protests. What risks may they sort of bring about or experience, and how to mitigate those, and maybe minors who are protesting, maybe they're 16, 17 or something, certain precautions that they may need to take.
So the hardest thing about, and we've seen, just as in 1964, the Civil Rights Act and the protests that led up to that, there were a lot of young people who were activists in that sense. We've seen one protester here made the news. He was 15 the first night of protests here in Denver, and it's like, you're a freshman in high school, maybe 8th grade, right? Like it's a very different dynamic with police when you're that young. Juvenile prosecution can happen in Colorado, at least, if you are 10 years old or older. So you are subject to arrest just as an adult would be. Now, the hard part is if your kids are there and you're a respondent parent, you are also required to be in court if they are arrested. In Colorado, every juvenile gets an attorney free of charge if their parents cannot afford one or refuse to provide one. I don't know whether that's the case in every state. I would wager it is not, because that was a recent law passed here. So kids have, juveniles and children have a different, issue. And then there's always the issue of potential harm to them. I don't think I've seen any sort of child abuse charges for parents exposing their kids to risk in this sense yet. That's not to say it's not coming.
Given how much violence there's been, I think,
Yeah.
I think not just also of the older kids, but maybe also parents who are bringing strollers to protest, like, you
Yep.
know, is that advisable, or is there a way to, you know, find other childcare? Especially if they're so young as to not even, you know, remember if the parents are looking to, you know, expose the children for an education or experiential sort of thing. You know, do they want to sort of bring that in as a cultural value? This is something that we do as a family, perhaps, but as a baby, you know, what would be the benefit of bringing a baby to something like that?
And as a mother of a toddler, like, I get it, right? Like, we've done the Women's March, a couple of different things, but at the same time, you have to be cognizant of, if there's a risk to your child, like, you have to leave. You have an obligation before anything to that kid, because there are reckless endangerment laws in Colorado. There's also knowingly or recklessly exposing your child to the risk of physical harm.
Right.
That is child abuse, and it's a misdemeanor in Colorado. I haven't seen that charged in this context yet. We're pretty, in Colorado at least, we're pretty safe during the day. Most of our events have been permitted and peaceful and that sort of thing. The marches have been very well organized. It's the evening and that transition to getting close to that 5 p.m. curfew where people are trying to get out and other people are coming in. Troublemakers are coming in, you know, there's always going to be that. We had a scare in Greeley. I think they shut down the courthouse on like a Friday because they'd heard that Antifa or whatever was coming to like the courthouse, and a bunch of rural counties were thinking that they were going to have violence and everything. And I'm not here to comment one way or the other on whether that's a terrorist group or not. But I think as the day wears on, people get tired and tempers
Drink
flare.
alcohol.
Alcohol's involved.
Mm-hmm.
Yep, there are public consumption of alcohol and drugs in Colorado. Marijuana is legal, although marijuana, generally speaking, is not going to be a big inciter for
violence.
Violent riots. But we have had a number of businesses who have been raided, looted, that sort of thing, you know, on Colfax especially, which is right next to where the Capitol is.
So Valerie, when I don't think we've touched on this slide yet. Maybe it would be good to just go back and anything we didn't cover around, you know, public versus private property.
Yeah, absolutely. So Justie highlighted that distinction between, you know, protesting on private property versus public. So I'm going to go through a couple of cases that really discuss that distinction. And then we'll turn to her for a few more questions. So on this slide, I summarize kind of the 3 basic categories that you see in the case law pertaining to, you know, why your protest location matters. You know, so there's public property, which historically it's considered the public forum, where your right to protest is most protected under the First Amendment. Then, as Justie said, you have private property, where, you know, the private property owner really gets to say whether somebody can protest there or not. And as Justie pointed out, you know, you can put up whatever sign you want on your own private property. You have to be careful of noise ordinances and things of that nature, but you can stand on your own private property and say whatever you'd like. And then there are areas that are called sensitive areas, for lack of a better term, but you'll find these areas in front of like healthcare clinics or abortion clinics, military bases, airport terminals, where the government imposes some reasonable time, place, and manner restrictions. So a few cases that discuss these distinctions between protesting on private versus public property in some depth are the cases that I've put up here. So the Hill v. Colorado case, U.S. Supreme Court case from 2000, struck down, upheld a statute that prohibited protesters from getting within 8 feet of an abortion clinic. There were grounds for restricting protests that close to the abortion clinic because it was blocking traffic, it was interfering with patients' right to access the clinic. So it was okay to have an ordinance prohibiting protesters from getting that close. On the other side, we have another U.S. Supreme Court case from 2014 that said a 35-foot buffer around a clinic where no protest could be held in a 35-foot radius, that was too broad. So you couldn't prohibit all protests within 35 feet of an abortion clinic. That was not narrowly tailored, and it wasn't related to the interest in making sure that people could access the clinic. And that seemed to impinge also on the traditional public forum, which is sidewalks. So somewhere between 8 and 35 feet is the sweet spot, I guess, if you want to protest by a healthcare clinic. And an old case, but a good one, United States versus Grace from 1983, upheld the right to protest on sidewalks surrounding the Supreme Court building as being just sort of the ideal example of the public forum is protesting on the sidewalks of the Supreme Court, which people are allowed to do and can do. This is considered to be, your pinnacle First Amendment right to protest right outside the courthouse. So these cases outline some guideposts. As you can see with the Hill and McCullen cases, it can get fact specific, especially when you're dealing with these sensitive areas like healthcare clinics. One question that I want to ask Justie, so if you are protesting in an unauthorized location, now private property or even one of these sensitive areas like in front of a healthcare clinic, what are some of the criminal charges that one can face for protesting in a location where you can't protest?
I think you're mostly looking at municipal violations once again. But sometimes you will have things, especially in like the Hill v. Colorado case. I'm pretty sure I remember that one. And I think that's why when we're next door to Planned Parenthood, we get people because we're the neighbor that's more than 8 feet away. Yeah, I think what you'll end up with is you'll have harassment charges coming, maybe some disorderly conduct, unreasonable noise, or fighting in public. It is an offense to spit on someone. So especially right now with COVID, it can be a very high level misdemeanor. And if you're spitting on a cop or an EMT, it can always be a felony as well, especially if there's an intent to infect. So when you have these protests that are going on and people don't have their masks on and spitting has become kind of this like, counter protest maybe? I don't even know what the right word is. Those are criminal acts. We saw an attorney recently, and I can't remember where she was. She was charged twice with spitting on someone who was protesting, and it was a white female attorney. And I'm like, at that point, you have to report that to the bar as well as, ethics council getting everyone involved in that. So it can be a felony. You can kind of run the gamut in what charges you actually end up with. If you're just present within 8 feet, most likely you'll have multiple opportunities before they will arrest you or charge you with anything. They will warn you to get back, warn you. But if you're getting up in someone's face, they may detain you. They may look at disorderly conduct. They may look at obstruction charges for disobeying a lawful order if there are police there and you refuse to disperse. Of course, if you ever resist arrest, you always have resisting arrest charges as well. So there's a wide variety of criminal conduct that goes along with this kind of stuff. And whether or not it's appropriate to charge somebody under these circumstances is definitely something different. Right now, we're seeing a lot of pushback, of course, with resisting arrest. Especially with freedom of the press and legal observers also being arrested at some of these protests.
So Justie, that brings up a really good point with, resisting arrest. And we see a lot of videos where people are very upset, enraged, that they feel there's unfair treatment happening and they are resistant. Where is that definition of resisting arrest, and how can you, sort of plead your case, so to speak, in the moment? Do you just never try and resist? What is the sort of best practice there in practical sense?
The best practice is just not to physically resist. Like if the cops are going to arrest you, they're going to arrest you. If you resist, you actually can cause new charges. So we have had cases where somebody was under arrest for suspicion of something else, right? And then once they finally put handcuffs on you, and try to take you to jail, when you're resisting arrest, resisting being handcuffed, that starts a whole new case. So I can get, as a criminal defense attorney, I have gotten the underlying charges dismissed, but resisting arrest is a new crime, and it starts all over. So the best bet is, if they're going to arrest you, they're going to arrest you no matter what you do. It'll only make things worse to resist. There are lots of people who will tell me, but resisting arrest, resisting an unlawful arrest is not resisting arrest.
Right.
There's very little distinction.
And that's really where you need an attorney, maybe.
That is where you need an attorney.
For you. Mm-hmm.
Yeah, and it is splitting hairs. And if you resist arrest, you're going to end up in a world of hurt, because they, at that point, can use force on you, lawfully so. And
so you really put yourself at risk, not just for the potential charges going through, but actually for physical harm.
Exactly.
Or worse. Okay.
And in terms of filing a 1983 claim and like getting rid of qualified immunity and like trying to sue the cops, if you're resisting arrest, you can't sue them for the underlying stuff. Like they're going to end up charging you with not just, curfew violation, but also resisting arrest. And they may have you dead to rights on resisting arrest, because there's 15 people, it's on video. You're
right. All the cameras that are around absolutely have to be pretty sure.
If you take a plea or are convicted on any of the charges, not just the underlying one, you often cannot have a civil suit against the police successfully at the end. So we're trying to get full-on dismissals of some of this stuff in order to be able to go after the police for excessive force or unlawful arrest or excessive prosecution even. If you take any sort of criminal conviction, even if a plea deal is offered and you're doing it to stay out of jail, you cannot sue the cops, generally speaking. So it's very, very hard under those circumstances. The best bet is to just be like, okay, arrest me, I will see you in court.
Right. The least potential for damage, whether, short term or long term. And really it sounds like you're saying, don't even begin to argue, even like, verbally. And maybe if you know that you are someone who is hot-tempered or prone to argument, you stay more in the back lines and not in the front lines where you're more visible to the police.
Yeah, the redheaded fiery tempers among us.
Is there anything else that you wanted to add here, Valerie?
Actually, your discussion here about interacting with the police sets up the next slide really well, where I collected a few cases on criticizing the police. The 3 cases I put up here, I'm not going to repeat what the protesters said to the police. It's some pretty profane language. But since we're talking about interacting with the police, I can go through these cases briefly, and then I actually want to ask for Justie's perspective on some of these issues. So the 3 cases I put up here make clear that the First Amendment does protect your right to criticize the police. And there are a number of cases upholding this right. The few I put up here are particularly colorful examples of that. So the Buffkins v. City of Omaha case, an 8th Circuit case from 1990. I just put a brief summary. I encourage everyone to look up and read the entire case, but the police did not have probable cause for arresting a protester who called the police an offensive name. I won't repeat that here, but it was during a protest. The police interacted with the protesters called the police a number of offensive names and were criminally charged, were arrested, and I think they were charged with disorderly conduct. But essentially, the only conduct as issue was that the protesters were calling the police names, and that was not actually probable cause for arresting a protester under those circumstances. The next case I put up here, this Houston v. Hill case, a U.S. Supreme Court case from 1987. This case makes clear that the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. Note, however, verbal. So you can take to the streets and say things about the police, but this protects verbal protests. Obviously, physical interactions with the police are not covered by this rule. And then the final case I put up here is actually a case from Virginia, a state court case where the court reversed a criminal conviction that was based on breaching the peace. And the conviction for breaching the peace was simply based, again, on a protester using offensive language against police officers. So the takeaway from the cases here is that simply saying bad things about the police in public, even calling the police offensive names, is not grounds for arresting them. It's not a crime. It's protected by the First Amendment. Now, having made these academic points, I want to get Justie's perspective about interacting with the police. So, if a police officer comes up to you in a protest and starts talking to you, what happened in these cases, the police officer or the protesters spoke back and said some pretty horrible things. If a police officer approaches you during a protest, are you obligated to speak with them?
No, not ever. Yeah, you don't have any obligation to talk with them at all. If they refuse to leave you alone, the best thing you can do is just remove yourself from that situation, go and to the back lines or protest a different area. There's no obligation to talk with the police. There's no obligation to engage in any sort of debate with them at all. The big thing that we see is they're at the point of arresting someone, right? Someone will automatically blurt out, what am I being arrested for? You have the absolute right to ask that question. And in fact, I would suggest that you do that. First off, ask always if you are free to leave. If they say you are free to leave, leave right then. Don't stay, don't talk anymore. If they touch you or put hands on you, ask why they are doing that and ask if you are free to leave. I mean, it is literally, am I free to leave? Am I free to leave? Am I free to leave? Every single time, you get there. If they order you to sit down on the curb and you're like, am I being arrested? Don't even ask if I am being arrested. Am I free to leave? Those are the words you need to remember. If you are under arrest, you absolutely do have the right to ask why you are under arrest. If they tell you, great, but cops can lie to you. They have no obligation to tell you the truth. So if they're gonna try and get you to flip on somebody else or snitch on somebody, they can persuade you however they would like. So they may tell you you're under arrest for something, and they may tell you you're under arrest for something that is not what you're under arrest for until later. The district attorney actually makes most charging decisions. So DAs can add charges up until the day of trial and amend charges as well. So what you're arrested for doesn't end up necessarily being what you are charged with when you go to court. Sometimes within 72 hours, they have to make that change. Later, they will make, in some other cases, they will make it later. But the three things to remember is ask if you are free to leave. If you're under arrest, ask if you, ask why you are being arrested. And then if you are under arrest, ask to speak to an attorney. That is it. And those are the three things. Am I free to leave? Why am I being arrested? I want an attorney. And not, I might want an attorney, or should I have an attorney? I want an attorney, unequivocal, because if you are questioning whether you need an attorney, they are still free to talk with you. But those three things should help you get through any sort of interaction with the police.
I feel like that's great advice that the defendants in these cases could have used. It happened during those, I think, kind of the gray area where the police were coming up with them, wasn't clear they're under arrest, and they started debating using some choice language. But
what we see too a lot is right now in the era of cell phones, right? Like 1987 and 1990, not everybody had a camera in their pocket. Now you have cameras in everyone's hands. And what you'll see is somebody's getting arrested and their buddy's over here taping the whole thing. The problem becomes when the buddy gets too close and the police aren't sure with what that out of the corner of their eye, what he has in his hand or what she has in her hand. Is it a gun? Is it a weapon? Is it a stick? Is it a cell phone? So they will turn on the observer and then arrest them. So there's a whole line of cases about you do have the right to videotape the police. You absolutely can stay and observe someone else being arrested. You cannot have your cell phone searched without your consent or a warrant. Now, if your phone doesn't have a password on it, it's a little easier to search those things. So put a password on your phone or put facial recognition on your phone if you have to, but a password is better than facial recognition. Police cannot search your phone without your consent, cannot search your body without your consent, cannot search your bag without your consent. The exception to that is if you are arrested, they can search you and your bag. They still cannot unlock your phone without a warrant though.
So you're not required to give your phone password or anything like that?
Never. Nope. They can go and get a search warrant later. And I've got a case right now with a juvenile where I'm like, good luck. It'll take you, a little while to get that search warrant on a stupid harassment case, right? Like it's the lowest class of misdemeanor we have.
Mm-hmm.
I'm like, by the time you have the search warrant done, we will have pled this case and dealt with it. And he will have this off his record. So those are my suggestions with regard to like cell phones specifically. Just maybe if you are going to videotape somebody, just say, this is a phone, I'm taping this. Don't ask for permission. The cops don't need to give you permission, but let them know you are just videotaping. And then they're less likely to think that you have a gun in your hand when you walk up beside them and hold it in their face. Stay a reasonable distance away as well. All right.
That is good advice. So the last slide that I have prepared circles back to something that Justie mentioned earlier about dispersing a protest, and when the police can do that. So what I found in the case law to date, which does not include obviously all the recent stuff going on now and all the unique circumstances presented today, but the short answer from the case law to date is the police can sometimes break up a protest. Justie, you mentioned this, but the police can't break up a protest unless there is a clear and present danger of riot or interference with traffic on the public streets or some immediate threat to public safety. So the two cases that I've selected that illustrate this principle in some depth, Collins v. Jordan, this is a case from the Ninth Circuit, and it basically just reiterates the principle that it is clearly established federal and state law that protests or assemblies cannot be dispersed on the ground that they are unlawful unless they are violent or pose a clear and present danger of imminent violence or that they are violating some other law or process. The police can't just come and tell you to disperse. There has to be that element of clear and present danger. And a case a bit more recent that I think really resonates today is the Jones v. Parmalee case from 2006, decided by the Second Circuit. Sotomayor was on that panel, but the Second Circuit in that case held that officers could not engage in indiscriminate mass arrests of protesters. So this was a situation where some people from the protest did things that were unlawful. There was a lawful protest and a few unidentified individuals in the group were rioting and looting and violating the law. And so what happened is the police came and arrested everyone they could find there. So Justie, now turning to today's events, where you see, I think a similar fact pattern to the Jones v. Parmalee case, where you have a bunch of people lawfully protesting, and then you have a few unidentified people, rioting or breaking glass in a store, and then the police try to arrest everybody. What have you seen, in terms of the fallout from that? I mean, it might be too soon to tell, but in terms of people who have been arrested simply for being there.
It's a little bit too soon for us. I think because of COVID more than anything, like every jurisdiction in this state except for one has jury trials and in-person appearances pretty much on hold until August 3rd. So they just bounced us another month, which means that most of these people who've been arrested for the protests may not have even gone to court yet. They would have a bond set as soon as they were arrested. They were able to bond out. Their court date's not going to be until August or September. Hell, I had one set in November on me earlier without even notifying me. I'm like, November, this is crazy. So I have a feeling like there's going to be a lot of dismissals on things. The hard part, right, is that Second Circuit, I don't know if that it would be persuasive here in Colorado, which is the 10th Circuit, but I don't know if there's anything directly on point here. State versus federal jurisdictions are a little bit different, but this should be exactly what we're talking about, right? Like, people are just getting arrested for being present. And you've seen it time and time again on the videos on Twitter and on other pages. And it's just, it's disheartening that there's this blanket attempt to just quiet the masses. And like, that is unconstitutional. Whether or not you agree with it, it is unconstitutional, right? So we haven't seen the shakedown of what will happen. But in my opinion, some of the cases we've taken and we've seen here are indiscriminate mass arrests. Like, people have done none of the rioting or looting. They're just present and can't remove themselves from the situation fast enough. Now, we'll see whether there's, like in self-defense cases, or I'm sorry, in conspiracy cases, there's a requirement that co-conspirators often have to take steps to thwart the conspiracy and remove themselves, denounce the conspiracy. I don't know whether that's going to be something that they're going to require in this. It'll be an interesting area of law, you know, like if you just stood there and did nothing while someone smashed a window, you know, like, I don't think that they can charge you under conspiracy theory, but I also don't know, they might try. They might try. And then there's no requirement that you are actually the one who does it. Just not stopping it was maybe enough. So we'll have to see. And there's always civil liability that you're concerned about too in these situations. Of course, like if someone is arrested and multiple people are arrested, say for vandalism, you're all jointly and severally liable for the damages. So that could be thousands of dollars in these cases. And if they're arresting 3 or 4 people who are like 15, 16, 17, there you go. You've got a juvenile who will very likely have $3,000 bill when they walk out of court without having to hire an attorney. Thankfully, in juvenile, you get a free attorney. But
so in that case, and I truly don't know, would the parents assume some of the responsibility for that financial compensation? No.
Yeah, and if he doesn't or she doesn't pay, there's always the possibility you will end up back in custody for failure to pay your restitution. That's getting less and less nowadays, but.
Okay.
Yeah.
What's the role also, and Valerie, I don't know if you can speak to this as well, for the obligation, let's say that there has been a lot of talk on social media that 2 groups are coming together to exercise their First Amendment rights. We're expecting a bit of a powder keg. What is the sort of obligation of the police to staff up and to protect citizens in that sort of scenario, to anticipate with a reasonable size force? Is there any sort of precedent there?
I was just going to mention counter protests, so I'm glad. Did you have cases, Valerie?
I actually did not have cases on this issue. That's a very interesting point. So I unfortunately can't, I can't speak to that, but that's something actually I want to get I want to look at right after this call, because that's an interesting angle, you know, thinking from the perspective of the protester. What are the police's responsibility then to keep the peace? And
maybe now also that we have more information at our fingertips than we may have in the 80s and 90s, and obviously before then, where there's a bit more information that's readily available and maybe even, you know, expressed by many people and not just one, that there is sort of a powder keg that's about to happen or being planned, or all the sort of setup for that.
My understanding is that obviously both sides have free speech rights. Like, whatever your perspective is, you have the right to come and protest or counter protest. The police, in my experience, are pretty much just there to keep the peace. So they can keep both groups separate, but they can't order one group or the other to disperse. without these requirements, right? If it gets to this point where, you know, there's a clear and present danger of imminent violence, I would hazard a guess that the police are going to tell everybody to go home. It doesn't matter which side of the protest you're on. They're going to treat protest and counter protests equally. And then generally though, they don't require you, if you're counter protesting or protesting, to be completely out of earshot of each other or out of visual range of each other, because that's the purpose, right, of a counter protest, is to be there and provide an alternate perspective.
Somewhat confrontational.
Yeah, as long as you're not confrontational and physically confrontational. Like, you can be confrontational and say whatever the heck you want on the other side of the street. That's what we see most of the time, is there's one area designated for this protest, there's one area designated for this protest. And as long as they don't intermingle, you're okay. But the police, I think, are more that they're kind of trying to be Switzerland. And it's a little harder, you know, when the police have a stake in this kind of protest, right? So they're
not really exactly a neutral party there in some people's minds.
Yeah. And so it's almost two counter protests. You have a protest, you have the police, and then you have another counter protest, and the police are kind of taking some sides. At least what we see in the media, and the media may be biased as well. So from my perspective, everybody has free speech rights. We have different views on how criminality should attach to your protest rights, for sure.
But also don't expect that if you're going to something where there is sort of murmurings of, you know, violence or, you know, confrontation that could be physical, and people are saying some very inflammatory things that has in the past led to violence, you know, don't expect that the police are going to staff up, you know, extra to protect you. That's not necessarily a requirement, and they wouldn't necessarily be negligent.
Right. Yeah, and it's very, very hard to sue the police. Civil rights attorneys have a hard road ahead of them. Although there's some laws that are changing, at least here in Colorado. Our legislature just passed groundbreaking legislation, and I haven't even had a chance to read the final bill yet, that limits police immunity. Does away with a bunch of protections. So it's a good move in the right direction, but as we see with a lot of politics, it's always a pendulum. Like, you're gonna have some states go real far one way and then maybe come back a little bit, but we do see that as time progresses. So I hope that the cases continue to shed light on the new era of protests, and during COVID, no less.
Valerie, I think you may have wanted to say something.
Yeah, just real brief, just to piggyback off a couple of things that Justie said. So as I mentioned, I did not see case law addressing the interesting situation of dealing with a protest and a counter protest, although that's not an issue I looked into. It's something I'll follow up on. But, you know, a couple of things that she mentioned. You know, as you pointed out, the police are likely to tell both sides to disperse. And actually, under the case law, the government shouldn't favor one side or the other, because that'd be seen as endorsing one message. So if they say these people can protest, these people can't, they're clearly picking sides, which is unconstitutional. Government's not supposed to be moderating like that. The second trend that I've seen in the case law, and to echo Justie's point about how hard it is to sue the police, it's very hard to hold the police, the government, liable for something they did not do, for failure to act. I mean, it's hard to hold them liable, period, but it's especially hard to say, you guys should have done X, but you didn't. You know, there's a bunch of discretion given to the city and the police for how to allocate police resources, and it's extremely hard to say that the police should have done something to stop violence, but didn't. You see this in child abuse cases where they try to hold the city or the police liable for trying to stop something that's unfortunate that happened, and oftentimes that's completely unsuccessful.
Yeah, maybe that also relates to what Justie was saying about, you know, co-conspirators who may or may not have actually been co-conspirators. You know, they just were standing by. How do you sort of hold them accountable or liable? So Yeah, this is a fantastic discussion. I can't believe we're already out of time. Really, time flies. And thank you all for joining us. Valerie, can you share, obviously you did a lot of this research through Casetext. Can you share if others want to get access to research tools like this, how they can access that, or if there's a free trial or anything?
Yeah, absolutely. So you can just visit us at casetext.com. It's like the word case and text, one word, and you can sign up for a 14-day free trial. We are also offering a deal, for attorneys who are providing pro bono representation in connection with any sort of civil rights work. If you contact us at support@casetext.com, we'll hook you up with free access. We're trying to make sure that attorneys are encouraged to go out there and provide pro bono representation in connection with either representing protesters or any sort of civil rights adjacent work.
That's fantastic. Thank you so much for sharing that. And if we can, join in those efforts and answer any calls that are coming into those firms or return calls for you, please let us know. You can contact us or visit our website at Smith.ai or hello@Smith.ai. Everyone, thank you for joining us. Valerie, Justie, thank you so much for your expertise and your time. This was a really fantastic discussion, and we will share the recording. And for anyone who missed those websites, that is casetext.com and Smith.ai. Thanks all. Have a wonderful day.
Thank you.
Thank you.